The final matter to come before the court this morning is Bayview Loan Servicing LLC versus Big Blue Capital Partners LLC. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, I'm keeping the clock this morning, and I can keep you apprised of the passage of time. The court's read the briefs, and we're ready to proceed when you are.
Hi, my name is Grace Doberdruck, and I'd like to reserve 5 minutes for rebuttal. This appeal involves an FHA note and mortgage. In paragraph 6B in the note, it says this note does not authorize acceleration when not permitted by HUD regulations. Paragraph 9 of the mortgage also restricts acceleration when there isn't compliance with HUD regulations. Appellant Big Blue Capital Partners LLC filed an opposition. They filed an answer that specifically denied that there were compliance with conditions preceding, or that there were compliance with HUD regulations, and specifically mentioned this face-to-face meeting requirement. When appellee Bayview moved for summary judgment, they didn't establish that they had complied with all conditions preceding. The affidavit of Dara Foy that was filed by appellee didn't mention that all conditions preceding were satisfied, and never specifically mentioned anything about HUD regulations. It didn't include any attachments to show that they did the steps that they were supposed to take under the federal regulations, such as sending certified letters to the homeowner or attempting to make this face-to-face meeting prior to foreclosure and prior to there actually being a serious default on the loan. And because the appellant specifically denied in their answer that these conditions preceding did not occur, appellee had the burden on summary judgment to move and establish that this had happened. Now, when appellant filed their opposition to summary judgment, they raised the issue that the conditions preceding weren't satisfied and that the HUD regulations weren't satisfied, and cited to BAC Loan Servicing versus Taylor, which was a 9th District case, that said that it reversed summary judgment when there wasn't evidence that the HUD regulations had been complied with. So under that standard, this case should have been, summary judgment should not have been granted in this case. Under the BAC versus Home Loan Servicing versus Taylor standard, appellee Bayview didn't establish that they complied with the HUD regulations. On September 16, 2015, the 9th District Court of Appeals decided Wells Fargo Bank versus NA versus Al-Wadawa, where the 9th District specifically held that compliance with HUD regulations is a condition precedent. And so, under this recent case law, it's dispositive of this case. Appellant Big Blue Capital Partners LLC would argue that even under the old standard of the BAC Home Loan Servicing versus Taylor, there was no evidence that the HUD regulations were complied with. But under the recent case law, Wells Fargo Bank NA versus Al-Wadawa, that specifically states compliance with HUD regulations is a condition precedent when the note and mortgage make this a requirement. And the note and mortgage in this case specifically requires compliance with these HUD regulations prior to foreclosure. And that's in paragraph 6B of the note and paragraph 9 of the mortgage. In the Al-Wadawa case, the court had cited to 24 CFR 203.606A, and the court stated that HUD regulations specified before initiating foreclosure, the mortgagee must ensure that all servicing requirements of the subpart have been met. And one of those requirements include having a face-to-face meeting or arranging a face-to-face meeting with the borrower prior to foreclosure. In this case, there was no evidence that ever occurred. An appellant is not the borrower in this case, but the borrower wasn't even named as a party in this case. But there was no exhibit, document, even a statement to show that there was compliance with the conditions precedent. And in
Well,
order,
what of the fact that the appellant is not the borrower on this note, and as it relates to the argument that whether or not they're standing to dispute?
what it is, Your Honor, is
Okay, I
that...
meant the appellant. Go ahead.
I think you're right. Appellant purchased the property from a bankruptcy trustee in Florida, and that deed is filed in the preliminary judicial report. In order for appellee Bayview Home Loan Servicing to foreclose, they need to show that this mortgage properly encumbers the property, and also that there's a default, and because this is an FHA loan, that they comply with the conditions preceded, in order to be even able to be entitled to file this complaint
Okay.
and to foreclose. And when they try to use the mechanism of foreclosure, appellee does not have standing to foreclose if they didn't comply with the HUD regulations, because this is an FHA note mortgage. And so appellee's claim comes through them complying with these regulations. And they could have named Tammy Lee Hillman as a party in this case. They chose not to. But technically, she is the only one who could have possibly been liable for the debt. And once this transfer of the property occurred, if appellee Bayview doesn't have the right to foreclose on the property, then their mortgage isn't a valid lien. And in addition to the arguments about the FHA compliance, which I've raised first here because the court's recent decision in Wells Fargo Bank versus Abu, there's also the issue of the note that was filed in this case. There was a 2012 foreclosure that was filed against Tammy Lee Hillman, and the note from Taylor Bean and Whitaker had an endorsement in blank. So now in this case, it's also important because Bank of America filed the foreclosure. Bank of America filed the 2012 foreclosure with this endorsement in blank from Taylor Bean and Whitaker. In the 2014 case, that endorsement in blank now appears to be an endorsement to the Secretary of Housing and Urban Development. And if you look at the complaint, you'll see that the endorsements on the note, including an allonge, doesn't match up with the assignments of mortgage. So we also have on this allonge, which is signed, there's two endorsements, both by David Briggs. He's also signing as attorney-in-fact for the Secretary of Housing and Urban Development. But on the allonge, it also mentions Bayview Acquisitions, LLC. There's no assignment of mortgage that involves Bayview Acquisitions, LLC. There's also, importantly, no assignment of mortgage that in any way involves the Secretary of Housing and Urban Development. So there's also a material issue of fact of whether this note had been altered from the time period of the 2012 foreclosure filing and up until the time of the 2014 foreclosure filing. And appellant did file an opposition to summary judgment with the affidavit of Sarah Twyford, where appellant authenticated the 2012 foreclosure complaint by affidavit, showing that the note had an endorsement of blank from Taylor Bean and Whitaker, and now in the 2014 foreclosure, it's like there's a mistake in the chain. The assignments contradict the new endorsements on the note, as well as the allonge. Because the assignment that was filed in 2012, which was also filed in this case, was from MERS to Bank of America, NA, successor by merger to BAC Home Loan Servicing, LP. And so if Taylor Bean and Whitaker sold the loan to Bank of America, then the endorsement from Taylor Bean and Whitaker to the Secretary of Housing and Urban Development doesn't make sense. There's a factual issue as to timing, as to whether there was an alteration, as to whether these David Briggs endorsements were valid, because he signed on behalf of multiple parties. There's no evidence that there was any power of attorney for that. There's also no authentication of merger documentation. And Appellee Bayview was claiming an interest in an assignment of mortgage from Bank of America N.A., successor of merger to BAC Home Loan Servicing. But that documentation was never filed. And so the appellee states in their affidavit that they've incorporated records of Bank of America. That record didn't make its way into the court. It wasn't properly authenticated under PNC Bank N.A. versus West. And it's a way that appellee is trying to claim an interest in this noted mortgage. They don't necessarily have a right to foreclose on.
And Counselor, you're just now reaching that 5-minute mark remaining, but I'll get reserved. Thank you.
Good morning, Your Honors. May it please the Court, Jason Whitaker on behalf of the appellee, Bayview Loan Servicing. Your Honors, I would submit that this case on appeal has one common theme in it, and that theme sort of is the term evolution. When you look at this court's case law and how it has affected summary judgments on foreclosure, the issue of possession of the note and the affidavits authenticating that note have been a major issue. I don't think I'm understating that in the decision that this Court of Appeals has issued. The argument in this case, the evidence in this case, though, has evolved from those prior cases in that there's specific evidence before the trial court that the plaintiff in the case, Bayview Loan Servicing, sent the note, the original note, to its counsel. There's evidence in this case that its counsel received that original note, and that the copies used in this case were made directly from that original note that was in possession of counsel since before it even filed the complaint. And when I use the term evolution, there's a lack of evolution in the appellant's initial argument before the trial court and in his initial merit brief, in that it completely ignores the fact that there is a second affidavit in the case, and that's of a custodian of the records for counsel for the plaintiff, counsel for the appellee, and that the affidavit of the summary judgment affidavit of the appellee itself also authenticates the fact that it sent the original note to its counsel before the case was filed. That's not present in any of the prior cases that this court has taken up, which the issue of whether the plaintiff's affidavit authenticated the note was proper. In that, although the affidavit does indicate what records were reviewed and not reviewed, the affidavit, though, further states that in those records, the original note was sent to counsel. And when counsel, custodian of records, authenticates the copies of the original note in the case, which I think it's certainly proper for that custodian to do, then the question of whether the plaintiff is in possession of that note essentially is a non-issue, as are the questions as to whether the note was, the allonge was affixed to the note, how it was affixed to the note, what state the copies were in when they were made. That affidavit went completely unchallenged at the trial court level. The brief in opposition to the motion for summary judgment doesn't address its existence at all. The merit brief of the appellant does not mention the existence of the affidavit from counsel, and the arguments in both instances by the appellant completely ignore the statements in the summary judgment affidavit itself that specifically testify that that note, the original note, was mailed to counsel well before the complaint was filed. And I would submit to the court, as counsel, there's a reason that was done, and it was specifically to address the question of, does the plaintiff have possession of the note when it files the case? In discovery, both parties have the opportunity to conduct discovery. The opportunity to inspect the original note was present. The opportunity to request under 56F the ability to depose the custodian of records of either the plaintiff or its counsel, that was present. The fact that the plaintiff has uncontroverted evidence that the original note itself was delivered to counsel for use in this case, before the case was filed, I think removes all doubt as to whether the plaintiff had possession of the note.
What about the argument about the failure to allege the satisfaction of the conditions preceding?
Your Honor, again, talking about evolution of the issues, this is sort of a case of first impression in which a non-borrower homeowner, non-borrower property owner seeks to enforce the provisions of a contract to which they were not a party. And which, under Ohio law, when you take ownership of a property, you are at least on constructive notice, if not actual notice, of the existence of the liens on the property, the terms of those liens, by virtue of their recorded nature. What was argued at the trial court on summary judgment, specifically by the appellee, by Bayview in this case, is that the FHA regulations, the HUD regulations that the defendant, the appellant, seeks to enforce, aren't enforceable by them. And even if they were, they're inapplicable, because they are limited solely to application by homeowner borrowers. This entity did not take out the note and mortgage. They're not a consumer. They're not a residential mortgagor, in the sense that there's no argument by Big Blue that the corporation resides in the property. And as specifically argued on summary judgment before the trial court, is one of the exceptions to the giving of a face-to-face notice, which again, I was focused on the fact that that's an attempt to conduct a face-to-face interview with the borrower. And it's very important, I think, that the term borrower is used, because the intent of the regulations is to protect because it doesn't apply to borrowers that don't reside in the property.
So the response is, even if it was in the original document, there's no FHA condition precedent that needs to be satisfied when this complaint is filed against this particular appellant.
Your Honor, there's an exception. There's an enumerated exception, and I guess maybe I'm parsing words, but under 203.604, there are 5 specific exceptions to the requirement that the face-to-face interview must be attempted. And one of those exceptions, or a number of those exceptions, are that the homeowner doesn't live in the property, or isn't the homeowner anymore. You know, that whole statutory scheme, the regulatory scheme, is meant to protect homeowners who use the property as their personal residence. It specifically exempts out investment properties. And so if it specifically exempts out investment properties, you have, again, clear evidence and admission here in an oral argument that this was a purchase from a trustee. This ostensibly is an
So it gets you
investment.
outside the regulation, but this gets you outside what was contracted for in the original, if it was originally contracted, that this would be something that occurred before foreclosure.
Your Honor, I'm not necessarily arguing that it gets me out of that. I guess I have 2 arguments to that. One is that they have no standing to assert that.
Right.
And the second is that the note doesn't specify anything other than, it says that the right to accelerate is limited by HUD regulations. And so the HUD regulations have to be examined, and when you look at the HUD regulations, when there's an exception as to why a particular regulation, and in fact the only regulation that's being cited here, doesn't apply to this case, then that transfers to the question of, even if the party asserting that the contract hasn't been complied with has standing to make that assertion altogether, that when the regulation is accepted from, that specific regulation is accepted from this situation, then it certainly couldn't be a condition preceding to this foreclosure. And again, I don't think it's insignificant that with regard to many of the arguments that are being raised here today, they weren't raised before the trial court. They weren't raised in the initial merit brief of the appellant. And so I'm not sure that it's proper that they're being raised now, either in the reply brief or for the first time at oral argument. In the sense that, again, when the court examines the briefing on summary judgment that the trial court relied upon in making its decision, the sole defense to the ability of the affiant to authenticate the documents that she authenticates. And I think it's important to note that there is no challenge to the issue of the loan account. There's no challenge that the original borrower is in default. There's no challenge that the notice of default was correct and sent. The challenge is to, does the plaintiff have the right to possess the note? Does the plaintiff in fact possess the note? Does the affidavit properly authenticate the documents? And then did the plaintiff happily meet its conditions precedent to foreclosure? And when you look at that affidavit and you look at the arguments advanced to the trial court on that affidavit, they didn't evolve. They are the same arguments that have been made to this court and to the common pleas court repeatedly, and don't take into account the fact that the affidavits in this case are different. And I don't think that's insignificant when you're talking about the right to enforce a note based upon possession. And what is the original note? Looking at the 2012 complaint seems immaterial when there's no controversy as to whether the court is looking at the original promissory note with the allonges affixed to it, unless there's some kind of discovery or some kind of other argument that is raised. Simply the fact that allegedly a different note was a different copy of a note was presented in a prior case doesn't itself invalidate the case when everyone agrees for, I think, all legal purposes that that's the copy of the original.
Did you not just say the copy of a different note?
No, Your Honor, I said a different copy of the note. A different copy of the note.
Okay.
As with any document, it can be copied at any state of its existence, and if something exists or doesn't exist at the time the copy is made, there was no evidence before the trial court as to when that copy of the 2012 complaint was generated, how it was generated, any effect that it has on today. And I don't want to stem too far, but the issue of the merger documents. In this court's prior precedent, what you had was a transfer of a note or a mortgage to a predecessor, and then the successor entity simply files a foreclosure asserting that it's the predecessor, that it's the successor entity. So in an example, you would have an endorsement or an assignment to BAC Home Loan Servicing LP. Now you have Bank of America before you asserting that it's the successor by merger. Here, in this case, you have an assignment to Bank of America, and then Bank of America asserting that it is the successor in interest to BAC Home Loan Services. And essentially, the successor language is nothing but superfluous language. It would be as if my wife enters into a contract using her married name, and then later asserts that she is, Lisa Whitaker, FKA, maiden name. The fact that she had a different name at some point in the future is immaterial because the contract was directly with her current name. And so I would just like to make that clarification to the court that when the transfer doesn't rely on the merger, and the merger is just a simple stated fact by the corporation that, hi, I'm Bank of America, I used to be BAC Home Loan Servicing, the fact that the transfer was directly to me, I think, makes that a non-issue, at least as far as it's a distinguishing factor from this court's prior precedent. So unless the court has any further questions, I think I've addressed everything that I need to.
Thank you, Counsel.
Thank you.
I'd like to point out in the opposition to summary judgment, it specifically states the affidavit of Derifoy never stated that plaintiff complied with all conditions proceeding to foreclosure. This is an FHA note and mortgage. The affiant did not allege compliance with HUD regulations. See BAC Home Loan Servicing LP versus Taylor, 2013 Ohio 355, parentheses, reverse summary judgment when a material issue of fact remained for trial as to whether the face-to-face meeting requirement was met.
But I think the argument is that it's not a material issue for trial for two reasons. One is the appellant is not a party to a contract, so if there's language in the contract requiring it. And number two, because there's an exception to the regulation which would otherwise require it. So,
Your Honor, with regard to the exception, if you look at the Wells Fargo versus Global case, the 2015 case, That case holds that the bank has the burden of establishing on summary judgment that an exception applies. The burden is not on the party opposing summary judgment to establish that some exception to the regulation or rule applies. The other issue is that in order to foreclose, paragraph 9 of the mortgage says acceleration, which is required in order to foreclose, acceleration and foreclosure is not permitted if the regulations are not complied with. And so appellee needed to establish that they complied with these regulations with regards to Tammy Lee Hillman in order to have a right to foreclose on this property. And that's what's missing here. It was raised by appellant, specifically denied in the answer, raised in opposition to summary judgment, and appellee never even so much as stated, we try to comply with these regulations. And the purpose of the FHA note and mortgage regulations is that the government insures these properties. So unlike other properties that go to foreclosure and they sell for way less, the government's paying the difference on the loss on these properties. And so the purpose is not just to protect whoever the borrower is, but it's to protect the government from having to pay insurance on these properties. And that's why they want these regulations complied with. And so the rule is specifically stated in this mortgage. If this mortgage is a lien, this mortgage requires that there's compliance with conditions precedent and with these HUD regulations, or the foreclosure is not supposed to go forward. And without appellee moving for summary judgment and establishing that these regulations were complied with, appellee was not entitled to judgment under the BAC versus Taylor standard or under the Wells Fargo Bank NA versus Awadawa standard. In addition, the issue on summary judgment was not what state the law offices of John D. Plunk received a note in. The issue was whether the original note had been altered sometime between the 2012 foreclosure and the 2014 foreclosure. And if you look at the assignments on the note and compare that with the endorsements on the note and compare that with the assignments on the mortgage, you will see that there is a contradiction, that it couldn't have happened exactly the way it appears in this 2014 case. Because the endorsements on the note couldn't have happened the way it appears in the 2014 case because it contradicts the assignments that have been filed in the 2014 case. And this court in BAC versus McFerrin says that if there's a severance of the note and mortgage, there couldn't be a foreclosure. It doesn't make sense to sever that, but here you've got the severance because you've got this, you've got these transfers that appear that they don't follow. And so there is a factual issue with the 2012 note that was authenticated on summary judgment and the 2014 note. And this court also held in Deutsche Bank versus Holden that there could be a material issue of fact for trial if there's different versions of the note. And this 2012 foreclosure case was a filing in the Summit County Court that this is what the note looked like and this is how the transfers occurred. And now that's being contradicted in this 2014 case. The other thing that was authenticated by the appellant on summary judgment in this affidavit of Sarah Twyford was that there was a bankruptcy filing by Taylor, Bean, and Whitaker. So the other issue was whether this assignment from MERS to Bank of America was ever even valid because of this bankruptcy filing. And if that assignment wasn't valid, which is an assignment listing Bank of America successor by merger, if that assignment was not valid, then appellee Bayview doesn't have a valid interest in the mortgage. And so that was a factual issue for trial as well, as whether there was permission within the bankruptcy court from Taylor, Bean, and Whitaker's Chapter 11 bankruptcy for the execution of this assignment of mortgage.
And counsel, regretfully, I need to inform you that you've reached the end of your allotted
Thank
time
you.
for today. Thank you both for your presentations this morning. Court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be linked to from our website. Thank you.
Thank
We
you.
are adjourned.